at all. It's gonna keep beeping at me for a minute. Just didn't quit beeping at me. All right, so that's now rolling. Go ahead and do this. All right, so this is evidence class. I'm going to move this camera around a little bit while everyone's rolling in. Move this over here. And it's going in the right place. Yeah. Zoom in a little bit. Cool. Yeah. Oh, right. All right. Good. Okay. Let's see here. Zoom. Boom. I think this is the one I need to update the Blackboard for because this is the one I'm moving a little slower in. Let's see right here. Actually, share screen so that way you guys can see it. Share screen. Okay, so this is this one. Actually, that's the next semester. Current courses. This is evidence. Yes, I've got videos up. Okay. Chapter 1. I do have chapter 2 in there. Okay, good. Let's see where we're supposed to be at. Let me click both of those. All right. Made a little bit larger there. That's good. So we should be a couple chapters in. So we can talk about guilt or innocence, aspects of the system, history and development. So let's see what the PowerPoints and kind of stuff has going on today. How many of these do I have download already? Bing. Oh, looks like I already had that one already. So that's Gardner. Downloads. Gardner. Okay, so we went through this. Bill of Rights. Constitutional rules. Improve challenges. Okay, cool. Close out of that one. We need to go to number 2. Excellent. Go ahead and download that. Get rid of that one. Boom, 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 boom. All right, so this is a little bit more about structure stuff on here. Some of the stuff we've already gone through, actually most of it probably have. So I'll move pretty fast through some of this pretty quickly. But there might be some points where we stop and have some discussions. We'll see what you guys want to talk about today. In terms of timeline, let me pull up I guess I closed out already. I thought I had the syllabus up, but I must have closed it. We'll keep that up because I want to see if I had anything set to be due. I don't have those on there yet. Okay, well, I'll pop out at least your first quiz in the next probably day, and then I'll give you at least a week to complete it. And then we'll probably start doing some assignment stuff soon too. All right, so got this downloaded. Excellent. Over here, we'll grab this thing too. So in terms of evidence and systems, we talked a little about history. I want to give you a longer conversation about history, but I haven't had time to go through my notes. Got a file of notes and they're kind of out of order. It's just going through scribbles and everything. So I haven't done that just yet. I'll go grab that at some point. Next week, hopefully. Get some time to files. Because it's a really interesting thing, and I need to remember who it's by. And so we'll move a little bit forward with that. We'll see what this does, and we'll do the PowerPoint real quick. Okay. So federalism, we talked about the differences between the federal and the state system. If I said dual sovereignty, you guys know that that's what? Ooh, maybe we didn't talk about that in here. I'm talk about some other classes because this is the beginning where it's like the first couple of weeks, and a lot of the concepts will overlap between the courses, I'm sure. Dual sovereignty. Actually, I might move dual sovereign. Spell that correctly. You guys ever heard of sovereign citizens? Yeah, I got at least one head shake on that, and a few looks like, what the heck's that? Bunch of weirdos, right? Maybe, maybe not. Here, kind of dealt with it a little bit in the Constitutional Rights, Bill of Rights. State sovereignty. Here, what we're talking about is it's something to do with both of those systems have possession of you at any point in time, right? Your actions can fall into both systems. So any one act, we have that double jeopardy clause. It's like, well, maybe, depending on how exactly it works, you have both that state and federal system. You know that part. We talked about thinking here. I know in policing, I've mentioned the same kind of thing because it's the same for them because they're ones dealing with it directly. Like, yeah, depending on what you're doing, where you're at, you might move into those two types of things. When you start getting into it, here, let's see. What does it say here? It talks about division between states and federal government, right? So to some degree, the states belong to federal government. The states themselves are more primary, I guess, than federal government is one way of looking at it. Answers to the federal government, but in terms of those things, it's the states that have, I guess, more authority is what you want to look at it to some degree. That's why, we don't talk about this kind of stuff. And it's like, how do you sit in criminal law, like abortion rights, that kind of stuff, right? As you move in different states, it has different laws associated with it. The big issue is that a federal issue where we need to deal with that as an individual right across the entire country, or is that something states should dictate? We have a system that's centralized and one that's decentralized to some degree, right? If I said decentralized versus centralized, you know what I mean? Maybe not, that's not in here so much. I might lose it, but it's more of a policing thing. So policing has to do, is largely a decentralized system. The court systems themselves are relatively centralized. Policing, if you look at city, state, county, federal, there is no clear chain of authority there, right? It's going to be very specific depending on what you're specifically dealing with. Like if you're dealing with a task force, yeah, it might be a federal thing. You might be a local level officer pulled into it. When you deal with the abortion stuff, basically what happened there was that those rules, Roe versus Wade, when it was overturned, it takes that power right over here. So the states are the ones dictating it, one step closer to you all, that kind of thing. Depending again on numbers, you're still playing the numbers game. That's kind of what's going on with that kind of thing. Okay, so we're talking about states, federal government. You think you need to talk about there? We get down here related to interstate commerce. Okay, so laws in this country are all over the place. If you're taking criminal law, I'll show you some statutes. I think most of those are all within. I'll have some federal ones, some generalized ones, and some one specifically to the state kind of thing. If you go and you look at the state statutes for first-degree murder, it's going to be relatively similar across all states. It'll be the exact same, right? As we're dealing with that, those things are going to change a little bit and how they're processed. And if we start interacting these two things, yeah, it can be real messy. Yeah, so here it talks about states' role, public safety, enacting laws, order, that kind of thing. Federal, yeah, Constitution's the law of the land there. As we talked earlier in the year, I mentioned like you realize since federal's the biggest, all those have to operate within it. So to some degree, it has some constraints on them. But when it comes to you, the states will actually constrict usually to a larger degree there. So if you've got more opportunity, more room to move. Okay. Each state and federal government has its own separate laws of evidence. Yeah. There'll be heavy overlap between the two. 10 amendments, individual rights, you already know that. Most crime is state crime. If you start looking at the numbers, basically what you'll see there is the law of numbers kind of thing. If you're dealing with something that's relatively rare like crime, the general rule is it does not exist. When you treat it as a rule, that's the rule. So like people with 11 colors. Yeah, they have them, but that's not generally the rule. Here, we deal with the crime level. Mentions common law. What they're talking about is the common law background, probably most states' laws. Common law, basically, you're dealing with history, how things were historically handled on almost a sociological level by the different groups. And here, we're usually talking about Western history, that kind of stuff. Federal laws are enacted by Congress. We've talked about that in other classes. We haven't talked about it here so much. So state legislators, they govern your state statutes. Congress is the one that does the federal level. So anytime that you vote on something. Okay. How many of you have ever voted before? Okay, a few. Those might be the first time. So depending on what's specifically going on and what election season it is, because they come up at different times, right? You might actually go in and like presidential election, you're gonna be voting for a number of people. Every now and again, you'll have a few things on it say like, oh, here's a revision to some type of state statute or something like that. You'll vote on it. So some of those require that, not all of them do. And so as the state legislators or Congress, whoever it is, as they meet together in their two houses and they discuss different acts. As they develop those acts, there might be revisions. It might be an act that revises, you know, criminal statute or something else. Usually you get a whole bunch of things done. It goes through both houses. If it gets approved, it goes through. As that happens, well, once it's signed off by whomever, you have a certain period of time before it actually takes effect. That's basically notification kind of thing. You have to have that in there. As that's taking place, once that's done, by that point in time, that's kind of fair notice. So that's one of those challenges that doesn't really necessarily apply. Do pretty well at notifications for that kind of stuff. That's kind of the general processes. Hey, it's a voting thing. You vote on those representatives. They're the ones who change the laws for you. They're changing it for you. Yes. Okay. Here's where it gets interesting. Interstate commerce laws, that kind of stuff. When you start getting to interstate commerce, that's one of the reasons why the federal government exists, right? You really think back in history. Actually, I'm going to go with a different story. If I can find it, I might look up the video and show you guys later. We'll get the sovereign citizens thing. So different people make different claims, that kind of thing. Sovereign citizens are known that way because they claim that they are not members of this country. They live here. They're their own sovereign, meaning they claim no relationship to these things. There's no purview, no authority. It's a whole group of people like that. Yeah, and so you have to run into some really, really weird things. You'll run into some really weird things with them, particularly and that kind of stuff. My favorite video I've ever seen was a sovereign citizen trying to, I forget what they were doing that was criminal. I think it was running drugs, something like that. Got pulled over and they started citing the Articles of Confederation kind of thing, interstate commerce, right? One of the biggest issues with this in identifying whether or not something's federal, does it cross federal boundaries? Okay, that's pretty easy. Does it affect federal commerce? Ooh, that's a different thing, right? Here's where you'd start getting into something like, okay, Oklahoma. In 2018, we had a major change to our drug laws. What was it? Yeah. Okay. How much of that stuff's getting in trouble with the feds? Some, not a lot though. What's going on there? Usually it's like black market stuff like that. Every now and again, what you get into is like those state boundaries, that kind of thing. If I start manufacturing here, how much of my stuff's making it out into this black market stuff? Is it starting to affect other states, right? It starts affecting other states. Then you start moving to that federal territory pretty quickly, right? Another example, Texas and suppressors. You guys know what suppressors are? No idea. Silencers, that kind of thing. That stuff that's going through the courts right now in a whole bunch of different fronts. Last I heard, since if Texas changed its laws to allow for suppressors, but only within the state, right? Within Texas, you could go to a Texas company and purchase a suppressor without going through the feds. Feds make you pay for it. There's a whole process involved, a little bit of cash involved too. You go through those processes, that kind of thing. Basically, they'll let you have it anytime you travel. If you're traveling with it, you have to notify the federal government. So if you go to move, you have to go fill a whole bunch of paperwork out first, that kind of stuff. So it's really complex, particularly if you got a bunch of stuff like that. At what point do those suppressors in Texas start to affect interstate commerce? That's a stickier situation, right? Not selling outside there, but are they making it across? What's that look like? That kind of thing. So it's like the boundaries here for where things cross over. Not as easy to always tell. SORNA. We'll talk about that one real quick. Sex offender registration notification, SORNA. I'll PowerPoint and see what it says in a second. First, I'll ask you, do you guys know what that is? Yeah, so basically what it is if you have a sex crime sex criminal, they have to fill out their information, keep it up to date, maintain it, so that way you can know where they're at. That kind of a thing. You get some questions about how, well, how punishment should work and whether that is one, right? That's kind of the underlying argument there is basically what you've got there is federal legislation kind of stuff. It's going to affect all the states. All the states are going to have to notify, basically make public where this group of people are, that kind of stuff. We talk about our system. That's kind of a dangerous thing because is that an extra punishment after the fact or not? When you start looking at that, there's actually part there because you can start looking at the state level too. So I'm a little curious to see what the PowerPoint says on that one. So hop over there for just a quick second because I don't know what it says. It says I downloaded it.
Just learning the definition of what it says.
Well, no, I was just kind of curious what it mentions in it because it's just going to probably mention it in passing in the book. Well, it won't go into much detail though. So I'm curious as to what aspects it brought up for this one. 16. All right, right here. So SORNA, yeah, that's just what it is, right? Basically, if you're moving around, start running into issues. Failing to register in one state, traveling, well, what have you done there, right? I moved to a different state. If I keep up with my stuff, I'm now violating that old state. What's going on there, right? Yeah, so you have the underlying argument. What is this thing to begin with? Is it a punishment? No. Right? That's right off from the bat because you have people, you've got your crime, you've got your conviction, and now you've got to carry an extra status for the rest of your life. Kind of, well, not the rest of your life, but for however long you have to register. Okay. Now you got aspects of how people move, state lines, and that kind of stuff. Movement's a very difficult thing. Yeah, so that's basically all that one is. Real. I'm surprised it doesn't mention that more. But we'll go into more detail. If I mention what kinds of stuff got that going, basically, anytime you start looking at these things, most of those are named. I'm trying to remember the names on there. I used to remember that off the top of my head. There you go, right here. Here's an example. Former military person convicted of failing to register while in the service had a conviction. Congress has the power to enact SORNA under necessary and proper clause. So that's what it is they want to talk about here. The authority there for what crimes where. And so basically you can see that there's an interplay. What's at the state level? What's at the federal level? And those lines are very, very blurry, right? Next up, I don't really care about that kind of stuff. We'll go with the outline, move a little bit faster. All right, so the law enforcement in itself, decentralized. That's policing. We won't go too heavy into it. If you start getting into it, you got a lot of different departments, a lot of different places, a lot of different levels. It will look very, very different. Basically, we start talking about the difference between urban and rural kind of thing. Most departments are kind of like single digits kind of stuff, very small. Some places will be very, very large. If you go to New York, it's like how many different precincts do they have, that kind of stuff. As you're dealing with it, you've got, well, all kinds of things here. Let's see, 17,000 separate law enforcement agencies. It says state, several local. You know, here it's like, okay, think about how many different jurisdictions you're under right now. How many different policing jurisdictions are you under right now?
City, county, state,
City, county, state, federal.
tribal.
Tribal. Where am I at right now? Yeah. Right. And so they start stacking up pretty quick. So you can see if you were to commit a crime right here, how many different jurisdictions would you violate? Right? How many different systems? How many different levels? It's going to be state and federal, but how many different crimes is that actually going to be? How many different charges can that be for that one act? Things can stack up. Right. Here mentions courts and trials. It's a different class. Prisoners of war and enemy combatants. They're just kind of throwing all stuff all over the place for these early ones. Here we go. This is where I want to get to. We'll stick this one first. Okay. Trials by judge and trials by jury. We've talked about trials a little bit. What's the difference between a regular trial with a jury and your bench trial?
Did you get to speak out?
You can speak to both if it's a full trial, that kind of thing. Whether or not you get a jury is going to be dependent on another number of factors. One, the type of crime that you committed. right? Serious crimes, you'll have a jury, that kind of thing. If you want one, you can go with a judge trial, a bench trial if you want. That's going to be a choice kind of thing. If it's like a misdemeanor, that kind of stuff. Going to bench trial against stuff, so it's non-serious, less serious, I should say, not serious. And so you got these two processes, jury and bench trials, that kind of stuff. Here's where you start getting to what it actually matters in terms of evidence. Yes. So these are your standards for determining whether or not it is actually evidence. Right. So this is going to be spelled with an E or an A. Spelled with an A. Relevant, reliable, and what's the word I'm looking for? Competent. There we go. Competent's the easiest one. Because it means not something. But we'll get to that in a second. So, relevant. What does that mean? Mm-hmm. Now give it to me without using the word itself. I look at it as kind of like pertinent, right? In some way, shape, or form. I think with a legal definition because it's long. In one way, shape, or form, this in some way either makes something more or less likely to be the case. It's going to be something that is additive in nature, and it will tend to make some facet of the case more or less likely, right? So we're starting to get to that. Is this a fact? Is it fiction kind of thing? Well, if it relates to the matters of the case and it starts to make it look like one of those facets is more likely or less likely, is it more the person did it, less likely did? Is it more or less likely to this specific characteristic of this specific case, right? That's what you get there. Reliable. What is that?
Sufficient degree of believability.
Yeah. Pertinent. I think it's sort of like strength to some degree. Right? The more relevant it is, the more bearing it has on the case. Right? To some degree, in some direction. Very flighty. Yes, I like these types. Reliable. Is it believable? There's ways to establish that kind of thing. Is it something that's true? Is it something that, well, competent? What does it mean that it's competent?
That includes relevant reliable evidence that is not otherwise rendered inadmissible.
There you go. It needs to be both of these things plus not inadmissible. Right? Is it competent? I can get it in. Yes. Right? Parties challenge the admissibility of evidence on, well, 3 grounds. Reliable, relevant, competent. It doesn't even tell you that. That's nice. I like that in there. All right, let's see what they say in here. So we can see what we can go into more detail. Okay, federal, states, I don't care about military stuff so much. Adversary system we've already talked about. Yeah, goals. There you go. Relevant. Okay. Prejudice is a big one, right? Confuses the facts, wastes the court's time, right? Prejudice. It's a rape case. We're talking about sexual history, right? That kind of thing. That's gonna cause people to start making judgments there, right? Then it becomes less of a question of what happened and the value of the person they're dealing with. It's like, ooh, that's not good. You don't want to do that. That makes it not what you're supposed to be testing you, right? Confuses the jury. It's just complicated. Why is it overly complicated? Is there a clear way to get it across? Easier. Yeah, sometimes, yeah. Waste the court's time. How many different pieces of evidence do you need to establish the same fact? Right? My goodness. What would be a good example of that? Trying to think of one thing that you have a whole bunch of copies of it of. Ooh. No, because now I'm just thinking copiers. But that's kind of what it is here. It's like we've already made this point. If you're just going to add in more evidence, just make it look more solid. At a certain point, you're wasting people's time. There. State drug possession prosecution may not introduce witness claim. Seen the defendant in possession of drugs on other occasions, right? Different behavior, different time. Does not relate to this. Has no real bearing on anything. That kind of stuff. Okay. May introduce testimony witness claiming the defendant had illegal guns and drugs in his apartment the day before the person did something wrong. Okay. The difference between those two things. Is there a difference there? Prosecution may not introduce evidence by a witness claiming to have seen the defendant in possession on other occasions, but they can say this person had this. Ooh. Some of you start getting the specificity. I'll give you a better example. Okay. Rather than what I've seen, we'll mix it up a little bit. I heard you say you committed this crime. Is that admissible or not?
Confided in me and told me that.
No, I'm just saying, I heard them. Yeah, someone says, hey, I heard so-and-so say they committed this crime. Can I let that person come in and testify?
I mean, in here, it's saying no, because someone underneath is saying that they actually did have the guns and illegal drugs.
It's one of those things start getting the hearsay. It's like, what are you actually testifying for? Right? What's the actual case? How are you using it? Right? It would be something like if it's just a guy saying that he said that he heard someone say this, like that's not substantial to the actual fact itself. Person was taking the fan and said, I was making statements about, here I was over here at this point in time I did this. Hey, this guy over here said he met with you on this other occasion and said he heard you say it. You did it. You're lying about this one facet over here. I'm actually using it to leverage into this other facet. One of those things that you have to kind of watch out for sometimes because you have to be very, very careful for how you do that, because that's one of those angles that people will look at. Lawyers will look at that. They'll try to, here's an opportunity for me to get this information that should not otherwise be admissible in. Right? Start seeing the loopholes for how they work the angles, is what I'm saying there. It's not just this and this, it's how it connects, that kind of a thing. It's a better way of trying to put that. Okay. With that one, moving forward, slow down. Reliable evidence, they're just going to tell you, yeah, it's a traditional degree of believability. Deemed unreliable is inadmissible, no kidding. Or justified charging person with a crime. Yes, each state has authority to commence criminal prosecution, sufficient evidence available to justify a crime. We've already talked about that stuff. Basically, we talked about those thresholds. That looks like the evidence that you need. You do need evidence to back it up. When you start talking about that, different forms, all that good stuff. Let's see if it gets to something substantive here. One accused of crimes entitled to his guilt or innocence based solely on base evidence trial, not on grounds of official suspicion, indictment. So that's where they're starting to get into the social side of things. We talked about that already too. So I'll move a little bit faster. Yeah, because they're not. Already talked about. Men's criminal prosecution is sufficient if evidence is able to justify those criminal charges. Meaning if they get past basically what is equivalent to probable cause kind of thing. You move into arrest. If you can show you've got more than likely you hit that point with grand jury hearing information that crime is more likely to occur than not, you move into the trial phase. And so that's this right here. Boop. Defendant was convicted to, okay, we need to probably talk about that kind of stuff. I know my criminal law class, the flow of trials and that kind of stuff, they want we'll check that out. Okay. So we talked about the trial itself, those involved. Outcomes. What are your outcomes from a trial? Guilty, not guilty. Innocence is a different thing, because if you start talking about innocence, we don't establish anyone's innocence. We just establish they're not guilty of a specific crime. Quick side note, why is it we do that? That's part of it. Part of it's that social side of things a little bit. I think in here I'm going to talk about inquisitorial versus adversary systems. If not, they mentioned it in here just kind of briefly. Can't remember if I mentioned it in here or in criminal law because it's kind of overlapping at the moment. So adversary systems, one where, hey, two parties fight and they have to determine guilt, whether or not you're guilty. Inquisitorial is where you determine your innocence, right? You have to fight to prove your innocence. That's an uphill battle, right? Just right from the get-go, let alone trying to establish that versus trying to establish that you actually did something, right? It's the hard thing. Proving your innocence is more difficult than proving you're guilty, right? And then if you take it to the time frames in which we're dealing with those different systems, basically we start dealing with this religion to some degree. The concept of original sin, you're all guilty, right? We're all guilty of something. It's just picking what we want to have someone guilty of. Different thing, completely different. Basically, the whole thing's invalid after that, and you become evil. Let's see. So, you prove whether or not the person's guilty based on facts. Those facts you'll be able to establish based off of witness testimony and conjunction of evidence. How those things fit together. There's a third option that can take place. What is it? You can have an acquittal, a conviction, or mistrial. There you go. So that's the third option. What happens if you have a mistrial? Go back to square one. Can't remember if I mentioned it in here last class. I know one of my classes on last week I mentioned lawfare. Have you ever heard that as a concept? That's kind of what it is. On the criminal side, it would be prosecutors, that kind of thing, would have to do it. Basically tying someone up in the criminal justice system in perpetuity, because if I can't get a clear answer one way or another, you just stay in that trial process. It's up to the prosecutor whether or not they want to bring trial charges again. Right? So that's one of those things that a lot of power there, a lot of authority, very dangerous. So that's the kind of cycle, and it will continue as long as there's public sentiment thing in theory. Sometimes it's not that, sometimes it's just politics. A little bit about that. Well, those different outcomes. Here, convicted of murder after 2 successive mistrials. So this is our third trial. Okay. During the trial, the defendant tried to introduce testimony of the third party committed the murders. That was excluded. Trial judge excluded one of the witnesses from testifying. Defendant appealed, filed a petition, basically to the Supreme Court. Supreme Court saw it, reviewed it for an error. Firm lower court's holding, denying relief, bad. Testimony is wrongly excluded. Trial judge's decisions to exclude it can only be overturned if it's substantial and injurious effect on the verdict. Okay, what's it talking about there? Appeals and when errors actually matter, that kind of a thing. So depending on what you're dealing with, what types of errors, they'll be handled differently within the system. If you took procedures, we talked about this. This is the harmless error doctrine. Basically what it is that should there be an error at trial and there's a conviction, well, what ends up happening there is that a subsequent decision is made as whether or not that error had an effect. There's your threshold. Is it substantial? Does it cause injury? Right? If you can't establish that, this decision stands. Basically, we start getting there as the trial itself. The processes are supposed to be fair, not error-free. Right? So there are errors here. Okay. Competent evidence. Yeah, otherwise not inadmissible. Communications between privileged parties. We talk about that in here. I want to say that, is that in here? I might have been from one class deal. We're talking about different things. So some relationships, that's not. Some relationships are privileged, right? So not everything is treated always the same. If you look at certain relationships, some of those are private. Patient, physician, husband, wife, those types of things. Why is that? Did we? Okay, good. So you guys don't. Yes, good. So you guys remember that. Good. Yes, because there's going to be some functional aspects of life that are of greater significance, like husband, wife, you're dealing with clergy. It's like you're freedom of religion, that kind of stuff. Medical care. Do you have medical care? Well, if it's no longer private, what am I going to disclose? What am I not? That kind of a thing. Massive effects. Here's where it talks about the accusatorial system, inquisitorial system, that kind of stuff. Yeah, I don't like it. Let's see, European special judges. Serious, I don't care about that. Disclosing information in the adversary system. Criminal charges have been made. Prosecution defense begins separate investigation of the facts. It's that discovery process, their investigations processes. While they're doing that, of course, they're going to be gathering evidence. They're going to be gathering witnesses, testimony, all that kind of stuff. I think there's anything I can pull into the next one. Many of the rules compel disclosure only apply to the prosecution. Why is that? Why would the defense not be compelled to disclose stuff? Yeah, they could do that. Okay, so in terms of how this works, some textbooks will talk about the relationship between judges, prosecutions, and defenses as a work group. I don't remember if this book does or not. They functionally do, because those people are working in close circuits with each other, close contact, a lot of site network kind of thing. As that happens, despite the fact that you have competing interests there, they do work together. You do have to work together. As you're doing that, if you're mounting a prosecution or defense, you don't want to, give away your tactics. You don't want to do that. You want to have a strong case, and sometimes surprise is necessary, that kind of a thing. Okay. Well, let's deal with that for a second. Let's say, on one side of the aisle, you have this thing right here. What is that? Whatever right there.
The right to remain silent.
Yeah. That extends to your lawyer. Right? Since they're the one compiling information, yes, they can disclose stuff, they will, but anything that's going to move over this way, are they obligated to turn over? Your lawyer, you're dealing with your lawyer. As you're having that conversation with your lawyer, you disclose, yeah, I actually did this. That's tell. No. Who is their responsibility to? Those who they defend, you individually. Right? Yeah. If I got a lawyer and I'm telling them something, it's like, I don't want to turn around and start talking to the prosecutor in that way. That's not going to be good. Right? At the same time, the prosecutor's aware of the fact that there is no way possible you're the one who could have done it. Should they say anything? Sometimes they don't. That's a Brady violation. That's It's probably one of these things. That's here, purchase the Brady rule. Basically, what is any exculpatory evidence? Exculpatory means it has the tendency to support the defendant's innocence. You have to turn it over. The system itself is one designed to keep people out of it, ideally, as much as possible, particularly if they're innocent. We don't want them in here, so we want to get them out. You will see that violated at times. That's not good. That's like, yeah, that's a good problem. How do you know if you didn't get it? You have to know what was there in the first place. There's no way you're going to know. That's not a shitty thing right there. Okay. So that starts getting to why you have different rules a little bit. There's a different purpose here. The purpose here is to make sure we don't get innocent people, not so that we make sure we catch the guilty. That's a really important facet of it. Okay. Alibi defenses, alibi statutes. Defenders could not have been somewhere to commit something because he was with someone else. Most states have no alibi statutes. So if you're going to provide alibis for the defendant, they do have to give you that list and go and ask them, was that person in fact with you at the time? Really? And where were you at? Hey, here's a photo of you somewhere else at that time. You know, that kind of a thing. All right. Most states know this. So the prosecutor can look into that. Yeah. That's where they start talking about the Brady exculpatory evidence. Evidence that shows innocence tends to show evidence. It's a longer definition than I can't remember. Prosecutor has that duty to disclose it. That's going to be that Brady rule. That is very, very, very important. Because like I said, you'll not know that it's there unless, well, you have to know that it's there, was there to know that it was missing. Basically what you're looking at. That's a much harder thing to do. I don't want to moving forward. Requirements extend to law enforcement officers as well. Okay, so that's something else I should probably talk about. Federal, state, any type of governmental official. Sometimes the rules apply to them, same as it does any other person. Sometimes it does not. That would be like whenever we start talking about testimony and basically the obligation to testify, that kind of thing, and whether or not one can be held liable for perjury. In these positions, you can't be. Doesn't matter whether you lie or not. Doesn't matter if you do it on purpose too. Right? You'll get in trouble at work if you do that though. But in terms of the courts, it doesn't matter. All right. Defines limits of exculpatory evidence. Yes. Okay. Despite the request from defense counsel, this is Brady, that original case. Due process error, right? Because it's both material to both guilt and punishment, right? If you don't provide that information over, you are weighing that scale yourself. That's a dangerous thing. Right? You end up with what's right in this case. Well, we'll say it like this. We'll do it like this. Okay. If you were a prosecutor or whatever, you have a bit of information that would invalidate your case, but you know for a fact that person actually did it. How many people would consider not saying anything themselves? You start to deal with that, the morality and the ethics involved. That is kind of a dangerous thing too. So that's why it is as important as it is, why those lines are as hard as they are. But you'll also see this is a little violated because as soon as someone's not watching, people do that. Okay. Boom, don't care about that. Lost, misplaced, destroyed evidence. So this is the best evidence rule that we're talking about here. Anytime you're dealing with these are the big ones. Best evidence rules has to do with, to some degree, that constitutional thing, to some degree, the relevancy kind of thing. We start dealing with is in terms of excessive evidence. I've got way too much evidence here. I've got 16 things that can prove to me that you were in this location at this time, right? I could enter in every single bit of that into the record. It's gonna be a lot for you to go through, unnecessary. Particularly if I've got a video of you walking into the scene, I can just enter that in, that kind of thing. It's a much easier way. It's better than, eyewitness testimony in some instances or something, or whatever. You look at whatever's best and you weigh it in tandem with everything that's available related to that specific fact that you're trying to establish in the case. And so best evidence might be, okay, this actually establishes 6 different facts, or this, and so you have to look at it that way too. Okay, if you start running to lost, misplaced, destroyed evidence, you start dealing with this right here, faith. How is it lost? What is, well, why? The kind of thing. I want to say that. I'm trying to remember what I had the conversation about that. Another example would be like that copy example I was thinking about. You go to a Xeroxer and take 3 copies of it. The one that actually gets entered in the record, is it going to be a copy? No, you're going to want the original there. It's entered into the court records, that kind of thing. They're going to want the original. More real world example that's a little bit less direct. Let's say this is a gun crime charge, and whenever you raid a person's house, you found several guns that aren't going in question, right? You'll still enter in those guns because that's what you have, right? If you had the other gun, the one that was of consequence to that particular case, instead of entering in one of the guns that you found to show that person had access to guns, you go get the one that was used in the crime because it's a better piece of evidence, that kind of thing. A Brady violation is discovered. The penalty is severe, including new trial or dismissal of charges. Yeah, I think it's earlier talking about that. Yeah, tactics, that kind of thing right there. If you think about that, that Brady violation. If you're going to lose a case, you look like you're losing a case. If you have a tactical violation, what's the likelihood you can get a new case? Right? Like, ooh, it's not going to work like that because that'd be the prosecution. Basically, what I'm thinking about there is the Rittenhouse case. If you actually watch the proceedings for it, you'll see that they make a number of Brady violations. There's a number of issues there. What happened was the prosecution started losing the case and saying, hey, we have some Brady violations. Right? Well, we might have a mistrial. We might not get a verdict at all. We can start over. Depending on what I do. Or you get the whole thing thrown out. That's a dangerous game. Don't play that game. Very important thing, but you'll see it won't happen. Okay. False or perjured evidence. See civil system. Right? You can get in trouble with courts for that, yeah, but there you go. Supreme Court made clear. Conviction obtained by the knowing use of false testimony is a denial of due process. Straight, basically simple stuff there on that one. Anytime that you know that someone's lying, you don't put them on the stand, kind of thing. Talks about civil commitments here. That's the last slide on this one. I'll let you go. This one's related to mental health stuff. The process involved with that. When we come in next class, I'll have a little bit more prep time because my schedule has been as busy that day. And so we'll have some more interesting things to talk about. I won't run from this PowerPoint page to do that. These are the big ones though: relevant, reliable, competent. Realize that their interactions across. Competent is sum total of this plus it's not admissible. You want to use the best form of evidence that you can, right? Remember your witnesses, your vehicle for that evidence too. I think that kind of gets us to where we need to be for right now. Cool. All right. Well, I will catch you next class. Have a great day.